Come to order, please. And for our second hour today, we're joined by Dr. Isra Levy from the Ottawa Public Health, He is the medical officer of health with that organization. Trevor Daru, a retired deputy chief of the Calgary Police Service, and Michael Crystal, who's a lawyer with Spiteri and Ursulak, LLP. Gentlemen, thank you all for being here. I guess, Dr. Levy, we'll begin with you with an opening statement, sir.
Good morning. Thank you very much. Merci beaucoup and bon matin. J'aimerais me présenter.
I'd like to introduce myself.
I'm the medical officer of health, as you've heard, for the city of Ottawa, and grateful to be here to share with you my perspectives from the front line local public health work, where we deal, of course, with prevention of and response to addiction, and more broadly with promotion of positive mental health. We know that the spectrum of medical approaches to addiction include prevention, treatment, and harm reduction, which are in practice interrelated, and of course also complementary with law enforcement. As you know, the current situation is serious and the risk of overdose is growing. Here in Ontario in 2015, there were over 800 unintentional overdose deaths. More people died from unintentional opioid overdoses in Ontario than from motor vehicle collisions. This, of course, from our point of view, is a human issue. It's not a statistical issue. It's a health issue. And though it has been felt most intensely in the western areas of our country so far, no part of Canada is or can expect to be unaffected. Early actions taken by a Good Samaritan improve health outcomes in the event of an overdose. They buy time for emergency responders to arrive on scene. But that only can happen if those emergency responders are notified. Many overdoses occur in the presence of another person, yet less than half of the people who witness an overdose call 911. When emergency medical services are not called following an overdose, there is unquestionably an increased risk of death, even if the antidote naloxone has been given to reverse an overdose that is caused by opioids. And I certainly note that many overdoses are not caused by opioids or are caused by multiple drugs, but there are things that can be done in all of those circumstances if emergency responders get there. In Ottawa, we have run a local opioid overdose prevention program for just over 4 years now. We ask any person who uses drugs and their family and friends to be trained to use naloxone. We, with our local partners, have now distributed over 1,000 naloxone kits to members of the public in our community, and we know of at least 100 of those that have been used at the scene of an overdose. But we also know that only about a third of people, in fact less, 29 of 101 specifically, of people who we are aware of used a naloxone kit called 911. Barriers to calling for help included especially fear of being arrested and fear of being found breaching probation or parole. Bill C-224 aims to reduce these barriers and from our point of view then is very welcome. If it was passed quickly, we could immediately begin educating those that we work with of the fact that they are no longer at risk if they call 911 after witnessing an overdose. So as you've heard, many jurisdictions have enacted Good Samaritan laws to encourage people to seek medical attention for an overdose or for follow-up care after naloxone has been administered. There is some evaluation work that we're aware of, not much. The effective overdose immunity laws, as far as I'm aware, are quite limited in terms of what we know about it. But it seems that their impact is growing. One study in Washington State from about 5 years ago, where Washington was, of course, one of the first states to pass such a law, has apparently found no indication from police or prosecutors that it has posed a serious impediment to the conduct of their work. More importantly, from my point of view as a physician, almost 90% of opioid users in that jurisdiction indicated that now that they were aware of the law, they would be more likely to call 911 during future overdoses. In the absence of a Good Samaritan law such as the one we were speaking about today, we on the front lines in health must rely on police departments' discretion as to when to attend overdose-related calls. While we appreciate the often collaborative nature of health and law enforcement relationships, and certainly we enjoy that in Ottawa here, this is too uncertain a strategy to ensure that people who use drugs will not be afraid of getting into trouble when they call 911. Je peux dire sans risque de me tromper qu'elle
I can say without risking being mistaken that Bill C-224 will save lives.
Ottawa, I am confident in saying that the Good Samaritan Drug Overdose Act will save lives quickly, and I strongly support the bill and request and urge that the Senate and that you pass it without amendments, lest there be a delay so that we can get on with educating our community in this regard. Merci beaucoup.
Thank you. Mr. Crystal.
Chairman Runciman, Deputy Chairman Baker, Honourable Senators, thank you very much for the opportunity to speak with you this morning about Bill C-224. The proposed Good Samaritan Drug Overdose Act, it is always a privilege to appear before the learned committees of the Senate, and this occasion is made all the more special by the presence of my 14-year-old son, James, whose cohort is very much the interest of this proposed piece of legislation. I speak to you today as a private citizen, father, and criminal lawyer who has practiced for criminal law for 25 years and has seen the ravages of opioid addiction up close. Quite frankly, the images are still with me. The 15-year-old boy in North Bay who loaded his father's shotgun and walked into a drugstore demanding oxycodone. The perversely corrupt pharmacist who re-addicted my client to opioids after he had been clean for 2 years, only to seek referrals from him. And finally, and most recently, a young Aboriginal boy in Cornwall Island who got involved in a human trafficking event on the water to be paid in oxycodone. Margaret Atwood, in her poem, Marrying the Hangman, wrote, "To live in prison is to live without mirrors. To live without mirrors is to live without self." Bill C-224 is a mirror. It is a reflection on the reality that people who consume controlled drugs, controlled substances together inevitably fail to call 911 when a friend is overdosing for fear of self-incrimination. Consequently, I submit to you that Bill C-224 will save lives and that it must pass as is without amendment. I will now turn briefly to the relative merits and limitations of the bill. Firstly, the hallmark of Bill C-224 is that it provides an exemption from possession of substance charges. It is my submission that the exemption applies at the very least to both the 911 caller and the overdose victim. As a piece of legislation providing an exception, the governing principles of statutory interpretation will require that the legislation be strictly construed. Page 483 of Sullivan on the Construction of Statutes states that, by the author writes, the court sometimes suggests that statutory exemptions and exceptions are to be strictly construed, or alternatively that a person seeking the benefit of the statutory exemption or exception must establish clearly that they come within its terms. I am led to believe that there may be proposed amendments to this legislation, and I recognize very clearly, this is the push-pull that we're up against. This bill is a private member's bill. It is basically all about calling 911 when someone is ODing, and it is meant to encourage someone to act. It is not a government bill. And the temptation by all of us is to amend it, is to make it better, is to look towards the broader picture, which is what legislation is all about. At the end of the day, I think it's a great trial balloon. It's a great step forward. And I think we have to realize it's about dialing that number, 911, in situations when there's an opioid addiction. It has the promise of things greater, but I say set it in motion, even though that is not typically how we think of legislation. I say in this particular case, because it will save lives, set it in motion, watch it grow, see how it's interpreted by the courts, and then build on it. And after all, we do have to remember that this bill has had the consensus of the other place. And for that reason, I think it has an added gravitas. So thank you very much, and I appreciate your time.
Thank you, Mr. Daru.
Honourable Senators, I am pleased to be here today to speak to Bill C-224, an act to amend the Controlled Drugs and Substances Act. The Good Samaritan's Drug Overdose Bill is an important piece of a much-needed comprehensive strategy to address the crisis occurring in our country. Fentanyl has created a health crisis that we have not seen before. In 2016, the British Columbia Coroner's Service reports 914 illicit overdose deaths. While the Alberta statistics for the same time period were not publicly available until 2 days ago, the Alberta government reports that from January to September 2016, there have been 308 overdose deaths, 193 related to fentanyl, 145 to other drugs. 2 days ago, they announced 343 related to fentanyl. While the response necessary to address this crisis is complex and multidisciplinary, many of these lives could have been saved with a timely medical intervention. It is incumbent upon us to identify and eliminate barriers that prevent or restrict those overdosing from seeking medical attention. The fear of prosecution has, in the past, presented such a barrier. Bill C-224 will serve to address this. The current fentanyl crisis highlights the challenges, issues, and dangers associated with the illicit drug trade. To be sure, while the harms of fentanyl make headlines across this country, other illicit drugs continue to devastate lives, families, and communities. Bill C-224 will not only assist with the current opioid crisis, it will also assist in providing needed and timely medical attention to those overdosing on other substances. While Bill C-224 will remove barriers to seeking medical attention, access to timely treatment is also necessary to have lasting impact. All too often, lives are saved through medical interventions only for the same individual to be back on the street suffering from the same addiction and vulnerable to yet another overdose. Bill C-224 will not only increase the ability to access emergency medical treatment, it will also provide the opportunity to engage treatment workers and programs when available. The complexities around drug addiction and the illicit drug trade are such that no single discipline has the ability to effectively address the problem. To have meaningful impact on this national crisis, we must adopt a multi-pronged, holistic approach to address both the demand and supply side of the drug equation. To do so requires a comprehensive, multidisciplinary strategy, a strategy that works across a continuum of education, prevention, intervention, harm reduction, treatment, and enforcement. Dr. Nicholas Etches, Alberta Health Services Medical Officer of Health, stated, "I agree the police cannot arrest their way out of this." He added, "Neither can we, doctors, detox our way out of this." Dr. Etches is referring to the need for effective harm reduction strategies. Harm reduction combined with treatment is critical to reducing demand. Another important part of the continuum is prevention through education. Treating addictions can be costly and difficult with varying levels of success. Prevention through education provides the opportunity to get in front of the addiction and remains the most impactful and cost-effective way to prevent these tragedies. Strong public communication, as well as age-appropriate messaging integrated into school curriculums, is critical to getting ahead of this crisis. While no single piece of legislation will eliminate all tragedies associated with the illicit drug trade, Bill C-224, combined with an effective communication strategy and proper training, will save lives. Honourable Senators, thank you for allowing me to speak with you here today.
Thank you. Thank you all. Very much appreciate it. And we'll begin questions with Deputy Chair Senator Baker.
Thank you, Mr. Chairman, and thank you to the witnesses for their very excellent presentations. My one question is to Mr. Crystal, Michael Crystal, who is well known in case law from Newfoundland and Labrador to Ontario, very high-profile cases, a very competent attorney. And my question to you is this, sir. This bill passed unanimously, as you pointed out, in the House of Commons. And you point out that there may be some deficiencies in the bill. You admit that in your presentation to us here today. And you've listened to my colleagues around the table put forward suggestions that should be made to improve the bill. You've heard it, each member of this committee. Now, you're advocating we pass this bill immediately without amendment. But, Mr. Crystal, if you were assured that this bill, upon being amended in this chamber, were to proceed to the House of Commons, where there is unanimous consent on this particular piece of legislation, improved legislation, that this would not take a place on the private member's docket at the bottom, as is normally the case, but that there would be unanimous agreement to put this at the top and to have it dealt with immediately, and that request would be included in our observation, our instruction that we can give to the House of Commons with every piece of legislation. If that were the case, would you not agree that that would be a better outcome for this legislation, and that you would in fact then suggest that, given that fact, that you would approve of the amendments being made?
Absolutely. I would go so far as to see, listening, I had the benefit of listening to the first panel. I am surprised that this is not a piece of government legislation, and I feel for I feel for the people promoting the bill that they have to walk this thin line of going before cabinet again and dealing with all members of other parties. I would like to see this bill become a Senate bill. It can become a Senate bill, and I think that that this table, and I guess I'm repaying your compliment, but I don't mean to do so. This table is the most important table in this country, and I'm very proud to have my son here because this is where it happens. This is where the Supreme Court of Canada reviews the transcripts of these proceedings when they're determining law, and this is where law is really made and made better. And I say to you, Senator Baker, I call your bet, and I raise it, and I say, make it a Senate bill. This is too important for the back and forth that sometimes occurs in these situations. It's a simple bill, and I agree. I agree with Senator Campbell. I have written, unfortunately, and I'll just take a minute, but I just want to say, incremental approach. I apologize because in my submissions, in my remarks, I was pushing for an incremental approach, and that's what I meant by trial balloon, but only because we all want to see it move forward. So I say to you, good on you, Senator Baker, for suggesting that it should go back and be at the top of the list. I say go further, make it a Senate bill. Everyone is here, and everyone stands by it in some way or other, but it can be made better, and it ought to be made better.
Thank you.
Thank you very much, Mr. Chair. I'm waiting for this to come on. It's not coming in. Thank you very much, Mr. Chair, and thanks to the witnesses for being here. And congratulations to Deputy Chief Daru. He retired recently from the Calgary Police Service. Senator Baker stole some of my thunder, Mr. Crystal, but I do want to, so for clarity here, this bill, as written, would not include those who are on parole, which conditions might include being around people who are using drugs, on probation. A lot of the people who are going to call, we expect to call 911, are going to be those people. It will not include other drugs. It will not include other types of offenses. It is a very narrow slice. If they truly understand it, they may not call. Yeah. And so I think you would agree that a little widening of the bill would be helpful if we're truly about saving lives. I think Mr. Drew just described half who wouldn't be covered, actually, half of the people who died last year. Yeah,
I spoke to Peter Rudin yesterday of Aboriginal Legal Services in Toronto, and he was very quick to point out that you really do have to have the bail conditions and the probation conditions and the parole violators. And the comments that I'm going to make are going to seem to slow down the bill, but I mean, I am encouraged by what Senator Baker says and what you've said, Senator White. It operates on a primary fiction, and that is that the person who gives drugs to another person has engaged in trafficking.
Yeah,
and to say that immunity does, that exception does not exist is to really turn a blind eye and to what trafficking is and potentially confuse jurists who will have to deal with it. We all know what has to happen with this bill. Laws are off the rack. They're not made to measure. Because if they're made to measure, they'll never work.
If I may, Mr. Chair, a short
Sorry.
follow-up? No, that's good. I appreciate that.
I'm sorry to reduce what we're doing here to tailoring, but...
The second piece, that nothing stops the government, should this be amended, from taking the bill and saying it's now government legislation, and we're going to fly it up the flagpole today if they wish.
Like they did
Becomes
with the
a priority.
fentanyl.
Like they did with the fentanyl precursors, right? They did it themselves.
I get that, and you know, I get that, but I have spoken with Mr. McKinnon's staff for a very long time on this, and they fought a very noble battle and have put together unanimity, which is not common in the other place. And we really, I think the thing is, I'm just asking you to consider, you know, the realpolitik that will happen when this goes back. And if you do think about that and think about the battle that MP McKinnon has fought and might have to fight in order to get this to become government legislation, I encourage you to think about how that could be lessened by if this were to become a Senate bill. So I say, yes, we are. I know there's a consensus here, but I say, let's remove any obstacles and give some thought to sponsoring this bill as a Senate bill.
Thank you very much.
Yes,
Crystal.
I
Thanks,
apologize.
Mr. Chair.
I apologize.
Thank you, Chair. And thank you for all of you. It's really good to hear from you, Dr. Levy, about your opinion. It meant, and from you, Mr. Darrow. You know, my friend, whom I have the greatest respect for, Senator Baker, has said, if the government, but we have nothing in front of us to say that the government will make this a priority, they will do the right thing, and when they do, they can better it. And, you know, when you hear a mother speak about her 17-year-old, and you know, you've said you have, and many people here have many haunting. I live in the neighborhood where this happens, 3 deaths happen a day. So, you know, this is happening now. And so while the government, there is no assurance that the government is going to make this the first bill. So in the meantime, don't you think this bill should go through now?
That was my, I thought you were addressing me. I don't mean to jump in.
Yeah, I am. Sorry.
Thank you. I do. I'm torn. You know, as a lawyer, I'm torn because I agree with Senator Joyal, I agree with Senator Baker, I agree with Senator White. I know as a lawyer to make this bill workable for law enforcement, for defense lawyers, prosecutors, judges, and Justice and Senator Sinclair, former Justice Sinclair. There are deficits here. At the same time, I would like to see this bill go forward. And I leave it to you to consider how that be best done.
Anyone else wish to respond to that?
Thank you very much for the opportunity, and thank you for the question. I am somewhat torn as well. As a citizen and I guess a hobbyist in law, I accept and understand the notion that it can be improved upon. But as a clinician and as a public health specialist, I asked my nurses yesterday, the nurses I work with on the front lines at our harm reduction program, what the hardest thing they do is. And one of them said to me, looking in the eyes of somebody who has lost a friend to an overdose, I can tell you that the moment this bill passes, on the street, in this town, there will be nurses having different conversations with people who use drugs. So from my point of view, there is an urgency, and good is the enemy of perfect is the enemy of good, in my opinion.
I would just add quickly that I think it is important that this does move through, and I think if it can be amended and moved through quickly, that's important. I think where this really rests, though, is in the ability to communicate to the people that this will truly impact. I mean, training in law enforcement, that can be done, but really what it comes down to is that person that's sitting with that 17-year-old person who's overdosed, do they believe that, in fact, they're protected by this? So I think that the communication around this has to be substantial, but it also has to reach that target population that we're looking at.
Okay. Very, very briefly? Okay.
I'll second.
Get you on the second round. Senator McIntyre?
Thank you, Chair. Thank you all for your presentations. I support this bill with or without amendments. So my question is more one of clarification. That said, I'm looking at the definition of overdose in the bill and would simply like to have your thoughts on this definition. The definition notes that a reasonable person would believe that the situation requires emergency medical or law enforcement assistance. If we look at the circumstances encompassed by this bill, chances are that the individuals on the scene may be impaired by drugs or alcohol. So my question is this: could the use of the quote-unquote reasonable person standard in the definition of overdose be problematic? And could I have your thoughts on this, please?
So, thank you, Messi. I'm not a lawyer. I don't know how a jurist would look at that conundrum. But from a clinical perspective, it's not that complicated. It's true that we may often experience the false positive, so to speak, where someone in fact calls, a paramedic shows up on scene and concludes that this isn't an overdose, it's perhaps a diabetic emergency, for example. But the reasonable non-medical or non-health trained person could just as easily make that call. And from our point of view as frontline practitioners, we would have it as part of the differential diagnosis. In short, I think that the definition as it stands works from a health professional's perspective.
There would not be a problem from a clinical point of view?
No.
No. Mr. Crystal,
Thank you.
you care to comment?
You know, it's a very good question. And the language is about being charged. It's not whether it provides a defense.
Exactly.
So, you know, one wonders, where does, you know, reasonable but mistaken fact fit into this if the person is wrong? I mean, I think that I think that there would be, from the perspective, I think what would be the precipitating event would be that there would be some sort of urgent circumstances here that someone would be responding to, and I don't think they'd be held to much higher of a standard.
Thank you.
Senator Sinclair.
Thank you, Senator Instrument. I asked a question of the first panel concerning the situation of an individual who believes his friend is overdosing and drives him to the hospital and drops him off. And Mr. Crystal, would you comment upon how you think that might fall into this bill?
Well, thank you for that question, Senator Sinclair. As I've said, the problem that we're going to run into with exceptions is that the interpretation will be very narrow. And what the question you raise, I cannot, as you know, answer definitively. And the question you raise raises the problem that may come before a judge as to whether or not, because, and there are cases that support this, but remember the section from Sullivan's book is, it's not only that courts sometimes suggest that the exceptions be strictly construed, alternatively, that the person seeking the benefit of the statutory exemption or exception must establish clearly that they come within the terms. And your question, I'm sorry?
They have the onus.
They have the onus. And your question raises that issue. And so while we think we may be affording them a protection, we may be giving them a partial protection. So this is why I'm torn. It is clearly, obviously, there are clearly problems with different circumstances. That's, but I'll just say in a word. That's why I say this is really made-to-measure type law, because it's all about the phone call. It doesn't really think beyond the phone call, the person who is ODing and somebody calling 911. It's not equipped to think beyond that. And obviously, that's part of its limitation.
Thank you, Chair. You're okay.
Senator Boisvenu.
Thank you very much, Mr. Chairman. I'll give you a moment to put on your earpieces. Can you hear me? Is it coming through? Dr. Levy, can you hear me? Can you hear the interpretation? It's channel 1, I believe, for English. Channel 1, testing 1, 2. Can you hear the interpretation? Can you hear the interpreter? Thank you. My question is for you. We are preparing to amend the criminal code, and we have to be pleased with what the result will be. We know that in American states that have similar laws, do you have any reliable data on the effects that such similar laws have had on lives saved? Is there any reliable data available on that? Thank you very much. And I'm sorry, I'm making efforts, but I'm more comfortable speaking English.
Answer is no. We're not aware of data with respect to lives saved. Even here in Ottawa, we can only draw assumptions about lives saved really from the number of times that the kits are used. And because of the challenges that we've described, even with the definition of what an overdose actually is, and how hard it is to define that in all circumstances, there really is no way to come up with a definitive answer. But there's reasonable grounds to believe that lives have been saved. And I did mention, I'm not sure if everyone was present, but I did mention the Washington study that indicates that law enforcement isn't, and prosecutorial duties are not impacted, or in that particular study, the conclusion was that they hadn't been significantly impacted, and that attitudes to calling for emergency services are definitely improved. But with respect to your specific question, we don't have that data that I'm aware of. Merci beaucoup.
Thank you. And Senator Baker and Senator Campbell raised an issue that appears quite serious to me. Often, overdoses are a cocktail. It's a mix of alcohol and drugs. And the bill is quite restrictive in terms of the kinds of drugs that could result in charges under this Good Samaritan bill. So would it not be better at this point for the committee to broaden the scope of the bill to include other kinds of drugs, knowing that people who are suffering overdoses are often have more than one kind of drug in their system, when this gives more discretion to the police on other levels? Thank you very much.
Practitioner's point of view, overdoses are very frequently polypharmacy, cocktails of drugs. In fact, the commonest is alcohol. If we could only get rid of alcohol, or at least too much of it. My interpretation is that but again, I'm an amateur at that piece, the protection is afforded if the individual calls for help. And the reason for the individual calling for help doesn't really influence the protection. So whatever the nature of the overdose, whatever the cause of the clinical condition that appears to be emergent, my understanding is the protection is there for the individual that makes the call. And if that interpretation is correct, then I wouldn't share the concerns. But others may be better able to speak to the validity of those concerns.
Senator Dupuis.
Thank you, Mr. Chairman. I have a question, first of all, for you, Dr. Levy, and perhaps a comment from the others. I'd like to understand, in the definition of overdose, it seems to create two components. The first of all, the first one that a doctor could assess, physiological event, which it results from the introduction of a controlled substance into the body of a person that results in a life-threatening situation. So that's one thing that you as a doctor could find, regardless of the second condition that we seem to be adding here. And that a reasonable person would believe requires emergency medical, or so in other words, it seems to me that there are really two components included in this definition, two levels. The first, which is objectively quantifiable by a healthcare professional, and the second, which seems to impose on the person making the call that person believe that healthcare professionals should intervene. Whereas that person, and if I'm that person, I don't know anything about medicine. I can't in any way comply with the second part of that definition or respect that. So in terms of the medical definition, first of all, is that first part something that corresponds to something that any doctor called upon to testify before a court would say, yes, that's how we would recognize an overdose within our community? Thank you very much.
Again, I'm sorry, I'll answer in English. Merci. I think we may be overcomplicating the concept of overdose. There is no specific medical definition of an overdose. Essentially, when an individual presents with altered level of consciousness, one of the possible causes for that situation could be an overdose. People can overdose on water. Mm-hmm. So clinically, the presentation will differ depending on what the substance is. So really, whether in a clinical scenario where one would then bring to bear the biological assessments and use tests to ascertain what in fact is going on, and what may be going on could be any number of poisonings or from toxic substances, or could be different physiological processes totally unrelated. What really is the issue is there an emergency situation that an individual can see another individual is not able to function? Okay. And what we hear, we see about 20, between us and our partners, we have about 20,000 service encounters every year with people who use drugs for needle exchange purposes or other types of interventions on the harm reduction spectrum. Somewhere around 10% of those people are under the age of 20. And those people, particularly, some of them are just experimenting. They're with friends. Their friends get into trouble. They identify that by the fact that they just can't rouse them. They're sleepy. That might be temporary. They may well arise or become alert again a few minutes later. But what we don't want is those individuals to be afraid to call 911 in the meantime. And it's those people, those suburban kids, the people, teenagers who are terrified, and we hear that they're terrified, to make that call. So really it comes down to, from my point of view, what I interpret the two pieces that you say, that it's the second piece that is more important in the question at hand. Would that individual recognize that the person that they're with likely needs help or may need help, and be prepared to make the call? Merci beaucoup.
Senator Dagenet?
Thank you, Mr. Chairman. My question will be for Dr. Levy. So, Dr. Levy, in your presentation, you mentioned that even opioid users sometimes have difficulty recognizing that that's what they're consuming. So I don't know if you have any idea about the awareness campaign that will have to accompany this legislation to reach young people and also to get them to understand the importance of calling 911. It's not the whole answer to have this bill. We have to reach these people, and they have to understand the need for calling 911. They have to understand they can do that and not be charged. But even if people who are using opioids have difficulty recognizing that, I'd like to hear your comments on that.
Merci beaucoup, and again, I'll speak English with apology. Thank you. My colleague, Mr. Daru, mentioned that same point, and I very, very much agree with it. Thank you. It is indeed how the potential user of the benefit or beneficiary of this kind of thoughtful amendment to the Act will be made aware of the changes and will be made aware of the implications of those changes. So that's really what we do in local public health. That's our essentially one of our core businesses. Is we spend a lot of time thinking about how we make people aware and how we manage to target the right message to the right audience in the right way. So in short, multimedia campaigns help, but at the end of the day, the best way to get a message to an individual is an individualized method, very labor intensive, very difficult. We have the advantage at the local level ourselves in health, our partners in community and social services, and indeed more and more our partners in law enforcement, where we spend a lot of time thinking about that, developing complementary messages, and trying to have multidimensional messaging going out, traditional media, traditional vehicles, social media, but indeed direct service interactions and making sure that those messages are consistent.
Merci beaucoup.
Merci.
Thank you, Senator Pratt.
As a follow-up to this, don't you have a concern that because of the limited scope of the exemption, that it cannot be of help to a certain number of people, that this communication effort will have limited success? Because obviously people will learn that some of them will not be protected. And therefore, since I suppose in many cases those are young people who do not trust the police forces, therefore maybe the communication effort will not have that success, that they will not trust that they are protected, and therefore the success will be limited.
Thank you again for the opportunity to add to that. I do not have that concern. In fact, the communications that we engage in with a target group for our messaging, we and our other partners, is a much broader message. It's a message about the dangers of using any medication inappropriately or any substance. It's a message about options to not use. It's a message about how to recognize problems if they arise. It's a message about what can be done if those problems arise. So this would be a small added piece that we would build into comprehensive messaging. And perhaps naively, my own perspective would be that we would be able to tack on a message of reassurance when we're having those interactions with people. And if that reassurance turned out to be false, then indeed your concerns would be, I think, well-founded. But we wouldn't know that for years to come. And in the meantime, my unusual optimism would be that that our law enforcement partners, our prosecutorial arms and our judicial arms, would in fact interpret this in a way that was consistent with the intent, and that we wouldn't need to be changing our message down the road because of things not going according to plan.
Thank you.
Senator Batters.
Thanks very much. Mr. Crystal, you give the best compliments. One of the last times you were here, you called me Justice Batters, and then, and today you said, and I think very fittingly, this is the most important table in the country. This is where law is made and made better, and I'm definitely putting that on Twitter later today. So thank you very much for that. I think that's very true. Listening to the previous panel where you heard some of the suggestions that a few of us made about how this law could potentially be made better, and I know that for all of us, we're trying to make the best law that we can on this and save the most lives we can. Which particular couple of changes do you think? I know you said your preference is to probably just pass this now, and it's just in a matter of which form, but which changes do you think are the most important to this very bill to make?
I agree with Senator Baker that all the schedules should be involved. I agree with my good friend Jonathan Rudin of Aboriginal Legal Services that parole violators and people on court conditions, and I know other people have said it here today, ought to be included as well. Look, Senator Batters, the thing about this is the way this thing has cast has been as an exception bill. I mean, you know, when you drill down, and that's what we do here, that's what people do here, we drill down into this. So it's not an immunity bill. We're not talking about non-prosecution, or it is not an offense. We're talking about will not be charged, which is problematic because cases that will come before the courts where there is no charge will inevitably result in legal argument, be it charter or what have you. So one has to, and I think this is the result of it being a private member's bill as opposed to a government bill. And I understand where the bill is coming from, but if we're really going to drill down into this and rebuild, then I think we also have to think about, is this properly an exception bill, or should we be talking about an immunity? Mm-hmm. And are we talking about a defense, or are we talking about an exception? Because the way the bill will be interpreted will depend on how we cast it. If we cast it as an exception bill, then there'll be great scrutiny and it'll be interpreted very strictly. If we look at it as a defense or an immunity, it'll be much larger. We also know, and I've thought about this, and I was thinking about Senator White's comments. Senator White, there's a centripetal and a centrifugal forces here. Centripetal being the bill is exception, so it's going to be narrowly construed. Centrifugal is law enforcement will seek to punish people they believe are guilty of offenses. That push-pull is going to really work out in a very complicated way in the courts. So if we're going to build it from the ground up, we have a lot of big questions to ask. But when I listened today to the other panel, and when I listened to Mr. McKinnon, who I have a great deal of respect for, and the other MP whose name I apologize for forgetting.
Doherty.
Yep. Doherty, thank you. I saw this as being all about the phone call, all about a limited situation, and I can understand why there is a need for that, to act on that. All I can say at the end of the day is, you know, 'tis to be done, 'tis best to be done quickly. And that is why I think somebody has to throw their weight behind that bill. It may be the Senate, because it's very hard, I believe, for Mr. McKinnon to go back as a private member's bill and say, I'm going to get the government on board with that.
He is a government MP. But
he is a government MP, but, you know, he's probably in tier 12. Anyway, but I don't, that's not my business. But I say to you, there has to be some heft behind this bill. We all realize it's a very important bill.
Thank you.
Thank you.
Senator Joel.
Thank you, Mr. Chair. Dr. Levy, when I look into the list of drugs under Schedule 4 and 5, in your practice, can you comment on the happening of overdose in the use of those drugs listed, the barbiturates and all the drugs. The way I see it is that they are the ones that are really what I call prescribed medicine. And we know the level of consumption by Canadians those days of antidepressant. I mean, have you seen the recent report? I mean, it has skyrocketed. So it means the possibility that there be overdose in relation to, to Schedule 4 and 5 is multiplied, in my opinion, by a great number in the years to come. So it would be very difficult for a person to determine if arriving on a scene or being on a scene, because that's where the bill is aiming, that person could make a judgment, will I call or will I not call? Will I be protected or not? Because what is the drug that has been consumed by that person? So it seems to me that on the basis of your experience, how can we evaluate the impact of the bill in relation with, in fact, the reality that lives, that you see on a daily basis?
Thank you again, Merci. So my interpretation of the likely applicability of this bill is for non-prescribed medications. Prescribed medications certainly may be taken purposefully or mistakenly in a way that they cause overdose. And certainly all of my comments related to unintentional overdose. And some of that unintentional overdose, increasingly here in Ottawa, about 2/3 of the intentional overdose relates to the use of what could be prescribed. But things like barbiturates, if an individual intentionally or mistakenly overdoses and someone arrives on the scene, it's my interpretation that they would typically not be someone who'd be at risk in the circumstances that we're talking about. The circumstances that we're talking about is where there's been some kind of illicit activity preceding the overdose. And that typically doesn't apply in a situation where an individual overdoses on prescription medication unless they're using that prescription medication in an inappropriate way. So in short, and it's been many years since I've practiced a lot of clinical medicine, but in my experience, that scenario is very unusual and wouldn't really be a concern to me.
Unless the drug, as for instance, has been stolen or have been trafficked on the black market or in any context into which those drugs on Schedule 4 and 5 would have been, got illegally or would have been trafficked illegally.
Absolutely.
In that context.
In that context, I see it.
So then they would not be protected.
Right, and that I acknowledge is a limitation. Yeah. But from our point of view, the utility of the bill, were it to pass into law, we would be communicating to our clients who typically wouldn't fall into that category, that they have protections that they didn't have yesterday.
Mm-hmm. Thank you.
Merci to you.
One final senator on the list, and for a very brief question, Senator Ahmedvar, and a comparable response, please.
Very brief question. My question is to Mr. Crystal. I'm struggling between perfect and good. I recognize we live in an imperfect world. I don't believe this bill will become a government bill. It's not in the mandate letter. Do you see a scenario where this bill is passed as is, without amendments, and then followed by a new Senate bill that covers issues of scope and circumstances as you have described them?
Yes, I do. And I in my original submissions, which I think you all have a copy of, that's what I was thinking, that it be a trial balloon, that we see how it works, and in the meantime, we work to make it better.
Thank you.
Gentlemen, thank you all for very helpful contributions to our deliberations. Members, your agenda indicates we were planning to do clause-by-clause consideration. Yeah, I think that is perhaps we didn't anticipate as much discussion as has occurred, and a great deal of it on whether or not to amend the legislation. So I think it's We're over time. I just want to explain what we're doing here. There's also been a suggestion that obviously we're going to delay clause by clause. We're looking at March the 1st to consider clause by clause, and also to ask to have justice officials here as well so that they can respond to any concerns or questions we might have. We're all in agreement? Senator White, briefly.
Just, I would suggest if anyone would like copies of the House of Commons Committee discussion, because some of the issues we had here were raised June 16th, or middle of June 2016, so everyone understands that this isn't news to most people.
Okay.
Thank you, Mr.
Thank you. Meeting adjourned.